few minutes today at some point when the ball is handed over to them?
Well, the prosecution's been pretty methodical and they've been telling their story, and I think they've been doing it very effectively. The defense has been very surgical in what they're coming in with, what questions they're asking, and what points they're trying to make with each witness as it goes through, rather than doing long, elaborate crosses with every single witness. Additionally, they've announced to the judge that they're not ready to say how long their case is going to be. And so it makes it really hard to know what they're going to do when they haven't shown their hands on cross and they're not even saying how long it's going to take or how many witnesses they're going to be.
Michael didn't show their hand in opening except to say, our guy's innocent. Your thoughts?
Yeah, that's right. It's tough for me, as I've been saying throughout this case, to really understand where the defense is coming from on this. They made a pretty bold statement in opening by indicating to the jury that their client was absolutely innocent. Nothing about their cross-examination has provided any support for that proposition. So I agree with Jeffrey. I'm not exactly sure where we're headed with the defense case, if any.
Yeah, and usually in cross, Jeffrey, you can figure out where they're going, right? They're building up a theme with the questions, but I haven't really picked up on that here.
Right, yeah, absolutely. You always want to weave your theme and your theory of the case through everything you do, from jury selection to opening to cross to the actual defense case. And here, we haven't seen any of that in cross-examination. It's either that they have nothing up their sleeve and are just getting through this trial for whatever reason, or they have something major up their sleeve. And it's really hard to tell which it is based on how they've conducted their cross-examinations.
Michael, could this defendant take the stand with a Hail Mary and have some sort of narrative that hasn't been disclosed?
It seems unlikely, given the amount of inconsistencies in his earlier statement and the state's case. Certainly it's possible. I don't think it likely.
Yeah, and throughout this, Chandler Halderson has been somewhat active over at the defense table. He writes on those Post-it notes and has gone back and forth with his attorneys. You wonder to what level he is participating in his own defense. From our vantage point, it's always very difficult to tell. But that said, in terms of a decision of taking the stand, Jeffrey, it's all his, is it not? If he says, listen, I don't care what you say about my habitual lying, I got a story to tell and I want to tell it, he'll get up there.
Yeah, absolutely. The decision whether or not to testify is 100% the defendant's. Obviously, they're going to take counsel from their attorneys and sometimes friends and family members, depending on the case. But they are always going to make that decision for better or for worse. As a defense attorney, all you can do is have them prepared so that if they make that decision, they are ready for it. And what I often will do is have the client kind of make that decision tentatively pre-trial, still prepare them in case they change their minds. Because if your client changes their mind in the middle of the trial and you haven't prepared them, you haven't done your job.
Michael, have you ever had a client that just insists on getting up there, even though you think it's not what they should do? And how do you handle a situation like that?
I have. There's a colloquy between the court and the defendant, whether he elects to testify or decides not to testify, asking the defendant if he's had sufficient time to discuss his choice with his lawyer, whether they've discussed pros and cons of him testifying. He understands that if he decides to exercise his constitutional right to remain silent, that they can't mention that to the jury. And in spite of all of that knowledge, it's still his choice either to testify or not testify. Yes, it's fundamentally the defendant's decision, and it is a fluid decision which can change from the start of trial, and certainly in a 2-week trial, from day to day or even week to week. Having said that, I still find it difficult to believe that, given the way the defense has approached this case, that he would decide to testify. But sure, if he wants to tell his story, frankly, he's got nothing to lose given the mounting compelling evidence presented by the state.
Yeah, and one could argue that he's told a lot of tall tales if the prosecution is right, and a lot of people believed him throughout his life. We'll step aside, take a break as the extended sidebar continues. More live testimony when we return. Stay with us. Welcome back to Court TV and our continuing coverage of the state of Wisconsin versus 23-year-old Chandler Halderson, accused of murdering and dismembering his parents. The state is expected to wrap up its case in chief at some point today, giving the defense an opportunity for a defense, a case in chief, if they so choose. And at that point, too, we will likely learn whether Chandler Halderson decides to roll the dice and take the stand. It's been an extended sidebar, and I understand it is just wrapping up. Judge Hyland now addressing the participants. Let's go back live.
It was one of your roles to review the email accounts that we just heard Detective Blank testify about, getting all those records.
Yes.
And when I say review these email accounts, did you in fact go through and read all of the emails?
Yes.
So specifically, I'm going to talk to you today about 4 different email accounts. Chandler Halderson at gmail.com, Spieth Daniel at gmail.com, Alyssa Brandt 64 at gmail.com, and Aaron Hoover at gmail.com. Did you review those email accounts?
Yes, I did.
As it goes to Mr. Spieth, Ms. Brandt, and Mr. Hoover, we're going to talk about essentially the entirety of those email accounts, correct?
That's correct.
From creation through when you got access to them.
That's correct.
As it comes to Mr. Halderson, Chandler Halderson at gmail.com, that was his personal email?
Yes.
Were there an extensive amount of emails in that account?
I'd say there were.
Okay. Did you review those emails?
Yes.
Were there ever any emails to or from anyone at American Family Insurance indicating that Mr. Halderson worked there in any capacity?
Specifically American Family, no.
When it comes to the company SpaceX, were there ever any emails regarding a job application or employments with SpaceX?
No.
Does the word SpaceX come up, in fact, at all in any of those Mr. Halderson's Gmail account?
No.
Okay. Does this document contain messages, emails, this is 549 I'm showing you, that were pulled out by you and other members of law enforcement in what you believe to be relevant to this case?
Yes.
Okay. I'll move exhibit number 549 into evidence.
Any objection other than as noted?
No.
And I'll note for the record, 575 is a USB containing it for display, and I'd move 575 into evidence and ask to publish it.
Those exhibits are received and may be published.
All right. So when we're talking about Mr. Halderson's actual Gmail account, were there emails in that account in between him and these people, supposedly someone named Mr. Spieth, Ms. Brandt, and Mr. Hoover? Did Mr. Halderson's own Gmail account contain those messages?
Yes.
And for purposes of what we're going to look at just first, talking about Mr. Halderson's Gmail account, we did not include those because we're going to look at them when we look at these accounts, right?
That's correct.
Okay. What types of messages were you looking for when looking at Chandler Halderson at gmail.com? What were you trying to figure out?
Any communication with anyone from Madison College, anything related to his employment, either at SpaceX or American Family, any communications with his parents, anyone else. If we identified somebody within the email that we would like to contact, then we went and maybe did an interview of somebody within that email.
Okay. So we're going to look at a number of emails, and we'll start with number 30. We'll just start here. This doesn't look like a normal email. It's in a different format. Tell us about the format that we're looking at these in.
Sure. As Detective Blank just spoke to, the data that he provides us to review as case detectives is within the Cellbrite Reader program. And so we can generate reports from the emails. And again, this is just number 30 within the report we created